Hi, I'm Elizabeth Gearhart. I'm a patent agent at Gearhart Law. And I'm here with the big kahuna himself, the founder of Gearhart Law, Richard Gearhart. So we are going to spend this time talking about the firm.
Well, thank you for having me. I'm so glad to be here.
So we do want to talk a little bit about Gearhart Law and why we think we do a good job for our clients. So Richard, why do you think your clients like working with you?
Well, first of all, we're competent, so we know what we're doing. We have a lot of experience in intellectual property. It's all we do. So we do patents, trademarks, and copyrights. Patents protect inventions, trademarks protect brands or the names of companies, and copyrights protect original works, artistic works. And so we've been doing this. I personally have been doing this for over 30 years. And other members of the firm have been doing it for 15 plus years. And so we've seen a lot of situations. We've worked with a lot of clients. We've gotten a lot of cases granted through the Patent and Trademark Office. And so we think we do a really good job of representing our clients.
So what is the success rate of the firm?
Well, it's hard to calculate, but it's better than 80% success.
So that means 80% of the patents that you file with the patent office, patent applications, I should say, mature into actual patents.
Yeah, and it's probably, the actual number is probably a little bit better than that, so being a little bit conservative there. But what we try to do is we try to set up the cases when they're originally drafted so that our level of success is high. We try to do a really good search before we file a patent or trademark. And by doing that, we're able to improve the odds of success for our clients. We just don't take any project. We're a little bit more selective about the projects we take.
So if somebody comes to you for a patent and they can't get one, a utility patent, let's say, do you just say, bye, see you later? What do you do?
Well, if the search doesn't work out, we'll work with the client and try to find ways to support them so that they can move the project forward. Maybe it's focusing on a different area of technology. Maybe it's focusing on trademarks and copyrights. But our goal is to support our clients and help them be successful with their businesses.
So how many clients do you have?
Well, we at the firm collectively have over 1,800, which is really exciting because when we first started the business 13 years ago, my goal was to have 500 clients. And so we have really exceeded that, kind of beyond our expectations. Gearhart Law has been an Inc. 5000 company for 2 years, which is not an easy club to get into. You have to show real growth in order to make that list. And so we're very proud of that achievement.
So Inc. 5000 is a compilation of the 5,000 fastest growing privately held companies in the United States.
That's right. So we're in very rarefied company.
Right. So that it's a tough list to get into, but 2 years.
And you can't buy your way onto the list. You have to actually have the numbers to get in. So it's something that we've been proud of.
Yeah. So why did you decide to become a lawyer in the first place? And then why go into patents where you have to have a science degree and it's very technical?
I went into law because I was interested in helping people. I've always been interested in business, and so I was interested in the intersection of business and law. And I lived for a while in Europe. I practiced with a large law firm there, Jones Day, where we did corporate deals and international commercial arbitration. I came back to the U.S. and I started working at an intellectual property law firm, and I realized that after 2 weeks of doing this work that it was just a perfect match for me, my personality and my talents, and I really enjoyed doing the work. I've always been passionate about intellectual property. It's just been something that I really like to do, and I've been doing it for 30 years. Passion pays off, and I think it's really, that translates into a real passion for helping our clients, a passion for doing the job right, a passion for finding the best strategies and the best ways forward for them. And I think that's part of the reason why we've been so successful.
I think so too. So strategy is an important part. So I think one of the strengths too is that people may come for a patent, but if they don't need one or can't get one, you don't just try to get them one. You tell them no, it's not going to work out. Don't waste your money. But here are some other things you can do to protect.
Absolutely. I mean, I spent a lot of time working in corporate America, and one of the things when you're representing a large corporation as a client is you're always aware of costs, and the idea is to avoid superfluous work. So I was basically trained to counsel clients in their own best interest, not necessarily what would make the firm the most money, but what do the clients really need? What's the best overall strategy, and how can they get the most value for their intellectual property dollar? And so if something is not going to be beneficial to the client, it's not going to be worth the money to spend it to do the project, then we're very straightforward with the client. We say, look, we just don't think that this is the best way. We think this would be a waste of money. And consequently, I think we've built a reputation for integrity and honesty in the way that we approach our clients.
So what if it does work out and somebody can have you work on a patent application for them and they have questions and they call you? How long does it take you to call them back?
We're right on it, so we value every new client contact, and so certainly within a day, usually within a few hours, sometimes within a few minutes. So we're a service-oriented business, and I think getting back to people is part of the service, and getting back to them as quickly as possible is important to start the relationship off in the right way.
So can you give me an idea of the costs of, say, a simple patent project that goes very smoothly, if there is any such thing?
Oh, no, there's some good ones once in a while.
And then,
it's kind of up to the patent office, but yeah.
So, and then the cost of something that's maybe a little more challenging because there are many different functioning parts. So what are the costs roughly?
Yeah. Well, patents, trademarks, it's an art as much as it is a science. And so as much strategizing as you do, it does depend to some extent on the examiner that you may get at the patent office. And sometimes, you have to work harder to convince them that the patent should be granted or that the trademark should be granted. So a simple case can go through after one response to the patent or trademark examiner. Sometimes it takes 3 or 4, but the client is always involved. They always know what's happening with their project, and they get to make the decisions about should we move forward, should we fight for broader claim coverage and spend more money, should we accept something a little bit narrower for less money, and we explain the process every step of the way so the client can make the best decisions for them.
So probably bottom end is 10,000, top end is 15 or 20. What do you
that's
think?
I would say probably more typically maybe $12,000 to $15,000 at the top end.
But that's not all at once. That's spread out over like 3 years, right?
Right. Most of the part of the money comes from doing a search, either a patent or trademark search in the beginning, and then preparing and filing the application. And then usually there's a time period. In the case of patents, could be anywhere from 2 to 4 years. And with trademarks, it's about 8 months. And so the costs come initially when the application is being prepared, and then there are additional costs later to get the application granted and allowed.
Okay, and I just want to clarify one thing about the examiner. So your application is an application that goes to the United States Patent and Trademark Office, kind of like filling out a loan application at a bank. It goes to a banker.
Like writing a term paper.
Yeah. And they get kind of to decide what happens with it, but they have to come up with reasonable arguments for why they're doing what they're doing. But they come back to you, and I don't know, 95, 98% of the time with a patent application, they'll say you cannot have this patent because of these reasons, and then you have to have strategic arguments with
Right.
them to convince them to issue this as a patent, right?
Right, that's exactly right. And it's a negotiation process with the examiner. We usually ask for more, and then we negotiate with the patent or trademark office and maybe accept a little bit less. So it's hard to ask for more later, so it's better to start out with your broadest claims first and then settle someplace in the middle with the examiner.
So back to cost a little bit. What if I call up to make an appointment with you just to talk about my invention? How much does that cost?
Well, we don't charge for our initial consultations, and sometimes our initial consultations can go on for a little while, but we want to make sure that any prospective client feels completely comfortable with us, that we have the skills and the knowledge to represent them properly, and that they trust us. I mean, the intellectual property system is complicated. And for people who don't do it every day, they don't necessarily understand all of the rules. And so they have to trust the person that they're working with to be representing them in their best interests, and that they understand and know what the best course is. And it takes time to develop that relationship. And so we're willing to take the time to get to know the clients and get to know their projects so that they can feel comfortable working with us.
And so if somebody does come to talk to you about their invention and maybe they decide they don't want to go forward or they want to go somewhere else or do something different, you're bound by attorney-client privilege regardless.
Absolutely.
And the whole firm is.
Absolutely.
So nobody at Gearhart Law can ever talk about anybody's invention without their permission.
That's right. And we've never had an issue with that. We take client confidentiality very seriously. Lots of times people approach us with inventions. They haven't even told their spouse about it yet, right? They need to have somebody that they can trust and who will listen to them. And so we think it's very important that the confidentiality be maintained so that they know that whatever they tell us will be kept in confidence, even if they decide that it's not a good fit for them.
So what's it like when they come to the firm? I mean, I guess they don't even have to come to the firm, right? You can do everything by phone or by Skype or Zoom or...
Yep, there's all sorts of modern ways to communicate, and we're happy to do whatever the client feels most comfortable with. Many clients want to meet us in person, and we're absolutely open and happy to do that. Other clients, it's just a couple of phone calls and some emails, and the whole relationship and the whole process takes place that way.
So how do the fees work? Because I know that there are a lot of different stages of this, and so how are the fees along? Do you do the 6-minute increments, and we're gonna
Well, sometimes we
set
do.
the timer, and 6 minutes is...
Most of our clients feel most comfortable with flat fees, so that way they can budget and they know what it's going to cost for each step of the process. And so typical consumer patent application might cost $5,200. A patent search might cost $790. If it's more complex technology, then our flat fees are higher. And so it's, for the most part, most of our clients like the flat fee model. There's also the more traditional hourly model where we bill hourly based on our time. And so for some clients, that's the most effective and most preferred way to bill, just because they're used to working with lawyers in that way. And we're more than happy to accommodate them.
But let's just clarify, the $5,200 is just to get the patent application on file.
That's right.
Not to prosecute it, which basically means negotiating with the patent examiner to get it allowed as a patent. So that costs more money, and that could be hourly or flat fee?
Yes, so if we do the patent application on an hourly basis, we'll usually do the prosecution on an hourly basis as well, or flat fee. So we tend to work the same way on the way through a project.
Basically, you file the patent application, and then what happens?
Then everybody pops a bottle of champagne.
It hasn't even matured into a patent yet.
Well, at least you got through the first stage.
It is like writing a term paper.
It is, yeah. No,
Yeah.
You're patent pending at that point, and you're able to commercialize your technology. And so you can go forward, work with a designer, try to find a license. You can do all sorts of different things with your project at that point, and you're able to go ahead and commercialize the technology.
And then it publishes as an application.
Eventually it publishes 18 months after the first priority document is filed, and it becomes available to the public. If you agree to keep the application limited to the United States, then you can opt not to publish the application. So that's also an option, and you can keep your idea a trade secret while it's pending at the patent office. Absolutely.
So priority date, can you explain what you mean by that? That's very patentese talk.
Yeah, so it's really just the that's the date when you file your patent application. So but everybody, it's in patentese, it's called the priority date. So I've never heard of an unpriority or a depriority date, but yeah, there's some patent humor for you, yeah. Worse than dad jokes.
So then, after it publishes, that's when you get assigned a patent examiner, and they send you something in the mail that says, you can't have a patent on this because da-da-da-da-da.
And what's so funny is that you get these letters, and they're written in very terse, legal government-ese, and it flips our clients out all the time.
And it's called a rejection.
And it's,
rejected.
you get rejected. And
But everybody gets rejected, so.
And some of our clients who are not used to this call us up, and they say, what happened? The examiner's being so mean. And we're just like, no, this is just part of the process. Everybody gets these letters, and we're used to working with the patent office, and this is just par for the course. But can be a little bit traumatic the first time you see one of those things. So yeah, so we try to warn everybody ahead of time, but usually it takes a conversation to get everybody back to a calm, relaxed state. So.
Right. So then the lawyer negotiates with the examiner, and they go back and forth, and you might even get a final rejection, but it's not actually final.
It's not actually final. No, nothing's ever final in the patent world. You can keep going for it as long as you want to, as long as you pay the government enough money. So no, there's lots of options.
But the one tricky thing that can really trip you up if you're not used to doing this is the deadlines.
Right. So, at Gearhart Law, we're very careful about the deadlines. We have computer docketing system that not only gives us deadlines, but provides reminders before the deadlines come. We meet on a regular basis. Different teams at the law firm meet to go over the deadlines on a weekly basis in order to make sure that the right follow-ups are done. Part of the service that the firm provides is that we nag our clients. If we send them a letter saying there's a deadline by a certain period of time and we don't hear back from them, we keep nagging you until you make a decision. Yes, I want to do it. No, I don't want to do it. But we don't just send you one letter, and if you, for some reason, forget to respond to us, then, and many clients do respond right away, but if you forget, we'll stay with it until we hear from you and get an answer. So it's part of protecting your interests, your legal interests, to make sure that nothing falls through the cracks. And some clients, they don't want to pursue it for whatever reason, and that's fine. But many times they'll say, oh, I forgot. And so they're grateful that we've stayed with them.
So what happens if you blow a deadline?
Well, there's some deadlines that are not repairable. And so we're especially give special attention to those to make sure that those deadlines are properly met. Other deadlines can be fixed by filing documents with the patent office, usually paying an extra fee, and in those cases, the applications can be reinstated. So, but we try to minimize that so that it's a very infrequent occurrence.
So then, when you finally get the yes, you can have a patent on this from the patent office.
Party.
Yeah. So what form does that come in? They just send you a letter saying we give up, or what happens?
No, the patent office never gives up and they never surrender. No, but they do send you a notice of allowance, and that's the document that everybody's waiting for, and it means that the patent office has decided that your invention is novel and non-obvious, and it means that you're an original thinker, and you've created something that at least nobody else has created, and so it's quite a mark of distinction.
And then you have to pay an issue fee.
Then you have to pay more money. You have to pay an issue fee, but then after that, the application is considered granted, and it's a piece of property. It's like a piece of real estate. You can, like a house, you can rent it through a license agreement, or You can keep trespassers off. Those are called infringement suits. You can transfer it to somebody else. You can sell it. So you own that idea.
Can you will it down to your kids?
Absolutely.
Do you get anything hard copy to show that you have it?
Well, you do. You get a certificate from the patent office, which is quite ornate with ribbons, and you can display it.
You get a hard copy of your patent.
You
right?
get a hard copy
Called
of your
the ribbon
patent.
copy.
Absolutely. One of my colleagues tells a story about a law firm sent a ribbon copy of a patent to somebody in Italy, and it was sent to the wrong address, and so they ended up going around the village looking for it, and they found that it had been sent to the wrong house, and the owner of the house had placed it on top of their fireplace and were displaying it because it was so nice. And they were claiming credit for it. So some people covet these things.
Yes. So what is the percentage of adults that have patents, would you say?
It's like less than 1%. So really being an inventor puts you in a pretty rarefied group.
So do you have any stories of any clients who have really used their patent to leverage success?
Oh, absolutely. We have, I would say, about a third of Gearhart Law clients have somehow recouped at least some commercial success through their businesses and through their intellectual property. So while not every business can be successful, many of them are. And we've seen varying degrees of success from products that are sold regularly on Amazon to pharmaceutical products that have been purchased by investors or large pharmaceutical groups in the tens of millions of dollars. So and intellectual property in each one of those cases has been an important part of the success. So it's an important business tool. If you're starting a business and you have something new, then you really need to look for ways to protect it.
So what do you like most about your clients?
Well, being an intellectual property lawyer is really like the best job in the whole world, because you get to hear about people's new ideas and you get to participate with them in the passion that they're feeling because they have a new idea, they're starting a new business. It's a very exciting time. And we find that their enthusiasm is contagious, and I really like working with people who are motivated and trying to do something new and creative. They're not just following the herd. They have a new idea. They're trying to break out of the mold, and I like people like that. And that's a lot of inventors fall into that category.
And they all have PhDs from Harvard.
No, I mean some of our most creative ideas that can come from anywhere, from anybody.
8-year-old kids.
8-year-old kids. We have an 8-year-old who got a patent, and that's the wonderful thing about our economy now, is that anybody who has an idea and a passion has a shot at turning it into something important.
And we do know people that can help you move your project forward, sell on Amazon, help you find sourcing of production, and all sorts of different things that a business person really needs.
Absolutely. We know people in the infomercial business. We know if you want to be on an infomercial, we know people who can help have your product manufactured, create marketing plans, financing. So we have a network of people that can support the inventor, especially somebody who doesn't necessarily have a lot of business experience.
So can I ask you a personal question?
Absolutely.
Let's find out a little bit about Richard.
Okay, absolutely.
So what's your favorite dinner? His birthday. We're taping this a couple days before his birthday, but I already know what it is. But no.
So it's like meatloaf is my favorite is my favorite home cooked food, right?
Yeah.
And potatoes. I also like steaks. I'm a carnivore. Hamburgers, red meat. Yeah, you can't go wrong with that. So those are my things.
And what do you like to do in your free time?
Besides sleep.
See, I want to convince you that lawyers really are people.
Oh, okay. Well, certainly when the kids were young and around, I enjoyed spending time with them and going to their football games and their plays and their band concerts. Now, since they're grown, I guess I really like to exercise. I mean, that's my big thing now. I get up every morning and I work out, and it's a great way to start the day, and I love feeling healthy. And so that's one of the big things. I like art. I'm kind of an art aficionado. I like music. I like classical music. And I've started reading more lately, so I'm really
You mean
trying-
besides patents and business books?
Right. I mean, yeah, I'll certainly still read the business books, but I'm trying to broaden my horizon. I'm starting to like history more, so I'm starting to read about historical events.
Awesome. So is there anything else you would like to add? Anything that anybody should know about you that's on YouTube?
Well, I mean, if you have questions about anything, just please contact me and we can talk. So be happy to talk with anybody about their projects, and we look for ways to help support our clients. That's why we're here.
And how many years experience?
It's close to 30 years now, so you're getting the whole enchilada.
So please call us or email us or fill out a website form if you have any questions or need any help, no matter what stage you're in your intellectual property. We probably can help you.
Absolutely.